Silence all, stand and remain standing. The Federal Circuit and Family Court of Australia Division 1 is now in session. Please be seated.
Just open the court, please.
On the occasion of the ceremonial sitting to commemorate the 50th anniversary of the Federal Circuit and Family Court of Australia Division 1.
Ms. Dowsett, SC.
May it please the court. I appear on behalf of the Victorian Bar at the invitation of this court on the occasion of this ceremonial sitting. I acknowledge the traditional owners of the land on which we're gathered today, the Wurundjeri Woiwurrung people and the Bunwurrung peoples of the Kulin Nation. I acknowledge their deep and enduring relationship to the land, waterways, sea, sky and community. I pay my respects to their elders past, present and emerging. I extend that acknowledgement and that respect to all Indigenous peoples across the continent and its adjacent lands, including the traditional owners of the lands from which those of you joining us on the live stream are sitting today, the traditional owners of the places upon which this court now sits and has sat in the course of its history, all of the Aboriginal and Torres Strait Islander people present today, and importantly, the Aboriginal and Torres Strait Islander people who work in and for this court. On the 11th of June last year, the Federal Circuit and Family Court of Australia Division 1, this court, and the Federal Court and Family Court of Australia, Federal Circuit Court and Family Court of Australia Division 2 launched their 2025-2027 Innovate Reconciliation Plan, At that time, one judge and 25 staff of the court identified as Aboriginal and/or Torres Strait Islander. The judge was His Honour Judge Matthew Myers, AM, the first Aboriginal Federal Judicial Officer. His Honour retired on the 4th of July last year. The majority of the court's Aboriginal and Torres Strait Islander staff are the court's Indigenous Family Liaison Officers. In their RAP, the courts acknowledge the Indigenous Family Liaison Officers as, quote, crucial to improving access to justice for Aboriginal and Torres Strait Islander peoples and achieving greater engagement for litigants and improving court services. The court also notes that Indigenous Family Liaison Officers, quote, can provide the courts with insight into ways to improve the understanding and application of cultures, country and kin. Such valuable and valued work. The court pleases.
Thank you very much, Ms Dowsett. This ceremony has begun with acknowledgement of country from Ms Dowsett SC, and I thank her deeply for accepting my invitation to deliver this welcome to country. The Wurundjeri and Pulong people, part of the Eastern Kulin Nation, are great and continuing people. On behalf of the court, I wish to acknowledge them as the traditional custodians of these lands and waters where we meet today, and pay my respect to their elders, past and present. I extend that respect to any Aboriginal or Torres Strait Islander peoples here today. Our court is a court that sits across this great country, all across it. Therefore, we acknowledge and thank the traditional owners of all those nations. We acknowledge the unique and ongoing spiritual and cultural relationship with their country. We express our gratitude for the sharing of this land. We also express our sorrow for the cost of that sharing. So good morning, everyone, and welcome to this ceremonial sitting to celebrate 50 years of the Family Court of Australia. I acknowledge the distinguished presence of so many guests, including the Honourable Michelle Rowland MP, the Attorney General of Australia. We are most grateful to the Attorney for her attendance today. We thank her sincerely for her support of our court and also support she's shown in the continuing work as we work positively together. Chief Justice Gageler AC, Chief Justice of the High Court of Australia, Justices of the High Court of Australia, Justice Gordon AC and Justice Stewart AC, retired Judge of the High Court of Australia, Mr Kenneth Hayne AC KC, Chief Justice Mortimer of the Federal Court of Australia and Judges of the Federal Court, Chief Justice Nile of the Supreme Court of Victoria and Judges of the Supreme Court, Justice Chambers, Chief Judge of the County Court of Victoria, His Honour Judge Vandersteen, President of the Children's Court, Deputy Chief Justice McCurry and Judges of the Federal Circuit and Family Court of Australia, also Chief Judge Gail Sutherland sitting with me, Chief Judge of the Western Australian Family Court, judges from other state and territory courts, and current members of the profession and members of the bar, also members of Parliament, including the Honourable Mark Dreyfus KC. Retired judges of the Family Court of Australia and retired judges of the Federal Circuit Court of Australia. And in particular, I want to thank Ms Peg Lusick for being here today. She was appointed in 1976, and I hope it won't be impolite of me to say you sit here today as a great honour to our court, and also at 103 you're doing pretty well. I am hoping that's something of longevity that may infect all our judges. Deputy Chief Justice McClellan AO, I acknowledge in particular because of the outstanding support he provides me and the leadership he's provided this court. It is a rare privilege and great benefit to our court to have such an excellent leader with the unique skill set being a former first law officer of Australia. But most importantly today, I want to acknowledge the Chief Justices of the Family Court of Australia, Elizabeth Evatt AC, Alistair Nicholson AO RFD KC, Diana Bryant AOKC, and the Honourable John Pascoe AC CBO. It is a distinct pleasure and privilege to have three out of our four former Chief Justices here today, and Alistair Nicholson is watching online, all of whom led this court with great distinction and should be very proud of what they've achieved. Mr Mark Costello KC, Vice President of the Victorian Bar Association on behalf of the Australian Bar Association. Ms Tanya Wolff, President of the Law Council of Australia. Mr Jason Walker, Not only our host from last night's extraordinary dinner, but also President of the Family Law Section of the Law Council of Australia, and members of the legal profession, including, of course, Mr. Dixon and the silks, the leading silks that sit at the bar table, distinguished guests. I'd also like to personally thank Chief Justice Mortimer and the judges of the Federal Court for extending us the privilege of using this courtroom. It is not the first time it's been made available to us for the Court's most significant occasions. I now invite the Attorney-General for the Commonwealth of Australia to address us, the Honourable Michelle Rowland MP.
May it please the Court. I too acknowledge the traditional custodians of the land and extend my respect to all Aboriginal and Torres Strait Islander people joining us this morning. It is a great privilege to participate in this celebration of the 50th anniversary of the Federal Circuit and Family Court of Australia, Division 1. I thank the Honourable Chief Justice Alstergren AO for inviting me to speak today, and I recognise the many eminent current and former members of the Federal Judiciary, the State and Territory Judiciaries, and the legal profession who are present, including my most excellent predecessor, the Honourable Mark Dreyfus KC MP. As the Commonwealth Attorney-General, I am committed to serving the Australian public, to upholding the rule of law, and to promoting public trust in the Australian legal system, in which this court plays a vital role. This court touches directly on the lives of everyday Australians and their families, and its jurisdiction covers some of the most personal matters heard in the Australian legal system. Its judges, registrars and staff often meet people at the most challenging junctures of their lives. It will come as no surprise to those attending today that the court has undergone various changes and enhancements in its 50 years of service to the Australian people. In January 1976, the court commenced operation as the then Family Court of Australia under the newly enacted Family Law Act 1975 with only 5 judges. This was a very different environment to that experienced today by our 41 specialist family law judges, which includes the Chief Justice, Deputy Chief Justice and 6 duly appointed judges who hear matters in the Family Court of Western Australia. In considering the design for a specialist family court for Australia, the goal was to create a helping court for Australian families with judicial officers chosen for their understanding of family law issues as well as their legal skills. From its inception, the court has adopted less adversarial procedures and provided services such as in-house counselling for litigants and families to address the profoundly human impact of the cases it hears. In the late 1980s, the offices of Deputy Chief Justice, Judge Administrator and Judicial Registrar were created, and registrars were empowered to manage escalating caseloads and pre-trial procedures. This change recognised the essential role that registrars play, together with all of the court staff, in enabling the court to efficiently manage its functions and caseloads to support Australian families. The court has always been extraordinarily busy, and in 2000, the Federal Magistrates Court, later to be called the Federal Circuit Court, was created, which has supported the court by hearing a large part of the family law caseload, including across regional Australia. In 2021, the 2 courts were brought together under a unified administrative structure, and the Family Court gained its current name of the Federal Circuit and Family Court Division 1. The Albanese government is committed to ensuring that the family law system continues to be accessible and safe and delivers justice and fairness for all Australian families. As part of this commitment, the government has progressed significant reforms to simplify and enhance the parenting and property frameworks of the Family Law Act. As a nation, our awareness and understanding of family and domestic violence has greatly improved since the court came into existence. This government is committed to better addressing family violence and reducing distress and hardship caused by protracted and adversarial litigation. The significant parenting reforms that came into effect almost 2 years ago streamlined the legislative framework for making parenting orders and addressed long-standing community misconception about parents' entitlement to equal time. These reforms were targeted at strengthening the focus on the best interests of the child and promoting the safety of children and their carers. Further, in June last year, key reforms to the Family Law Amendment Act 2024 commenced to ensure the economic consequences of family violence conduct is considered in family law property settlements where relevant. Over the past half-century, the court has adopted many innovative approaches that support families to resolve matters with dignity, with improved outcomes for all involved, including vulnerable parties and children. I would like to take the time to highlight 3 areas of recent accomplishments in the court. One such innovation is the Court's Lighthouse program, a world-first initiative focusing on the safety of children and vulnerable parties. Lighthouse supports families from the very start of a matter through early detection of safety risks and then works to proactively respond to them through tailored case management, including the use of specialist lists such as the Evatt list. I acknowledge the Honourable Elizabeth Evatt AC, the Court's first head of jurisdiction, who is here today and after whom the list is named. 86% of the cases before the Court involve allegations of family violence, and the Court has played an important role in pioneering change to better respond to these issues. The success of the Lighthouse program has been recognised both nationally and internationally, and it has had a meaningful impact on the most vulnerable of Australian families. Indeed, it was certainly an initiative I was thrilled to hear was in place upon my elevation as Attorney-General, and I congratulate Chief Justice Alstergren for being a champion of this. I also acknowledge the Court's ongoing commitment to access to justice for First Nations families. 1 in 15 family law applications involve a First Nations party or child. The Court has worked alongside the community to develop the Indigenous Family Liaison Officer program, which supports First Nations families to meaningfully engage with court processes and improve cultural safety. The specialist Indigenous lists have also been instrumental in providing culturally responsive case management and supporting positive outcomes. In recognition of the importance of the Lighthouse program, the iFlows and specialist Indigenous lists in supporting Australian families, the government has recently announced an additional $33.8 million to continue these significant initiatives for a further 2 years. Finally, it will be remiss of me not to mention the positive impact of our four-legged friends in the National Court Dog Program, who also work exceptionally hard to support litigants and children across Australia to feel safer, calmer and more comfortable when engaging in court proceedings. In 2022, the National Court Dog Program began with a successful pilot right here in the Melbourne Registry. In 2023, this pilot led to the swearing in of the Court's dog, Poppy. The National Court Dog Program has now grown to include an impressive 7 facility dogs across Australian registries. I acknowledge Guide Dogs Australia and the various legal organisations who have generously supported this program. I've already personally met Poppy and also Molly from the Parramatta Registry, and I look forward to meeting many more furry friends this term. The Court's focus on trauma-informed innovations and responding to the needs of vulnerable children and families, many of whom have experienced family violence, should be commended. In conclusion, I take this opportunity to congratulate the Court and all of its judges, registrars and staff, past and present, for the many achievements and contributions they have made to Australia's family law system thus far, and for serving the Australian community so well over the past half-century. I recognise the immense benefits that the commitment to service demonstrated by the Court and all who work here has had when supporting Australians in their time of need. As Attorney-General, I am looking forward to continuing to work with the Chief Justice and the Court to innovate and strengthen access to justice and to make a real positive impact on those in our community who rely on its services in their time of need. May it please the Court.
Thank you very much, Attorney General. Mr. Casillo.
May it please the Court, may I associate myself fully with the acknowledgements of country so movingly made by my learned friend Ms Dowsett and by you, Chief Justice, and by the Attorney, as I too acknowledge the traditional owners of these lands and all lands on which this Court sits. It is a privilege to address the Court today on behalf of the Australian Bar Association. Both the President of the Australian Bar Association, Michael Izzo SC, and the President of the Victorian Bar, Fiona Ryan SC, regret that they are unable to attend. A Golden Jubilee is a milestone that invites both celebration and reflection. It invites us to consider what kind of court this has been, what kind of justice it has sought to deliver, and what it has meant and continues to mean for the lives of Australians. When the Family Law Bill was introduced to Parliament in 1974, the then Prime Minister, the Honourable Gough Whitlam, observed that the determination of how best to enable broken marriages to be dissolved was very much a human as distinct from a technical legal problem. Those words captured something essential about the reform that was to come. The Family Law Act was not merely a change in procedure or jurisdiction. It was a fundamental reimagining of how the law should respond to the most personal of human difficulties. Before the Act, a person seeking divorce was compelled to air their most private grievances in public proceedings. The introduction of no-fault divorce was a reform of profound significance. It recognised that within civil society, dissolution of marriage is not a failing to be adjudicated, but a human reality to be managed with dignity and compassion. The Family Law Act gave institutional expression to those imperatives. A vision of that kind required leadership equal to its ambition. The appointment of the Honourable Elizabeth Evatt AC as the first Chief Judge of the Family Court was itself a moment of historic significance. Her Honour was the first woman to lead a federal court in this country, and the task that confronted her was formidable. To appreciate the scale of what Her Honour achieved, one must recall that she was charged with building a new national institution from nothing, recruiting its judges, developing its procedures, and establishing its culture, all in circumstances where the very philosophy of the court was a departure from everything that had gone before. Her Honour had a vision, and it was one of remarkable humanity. Under Her Honour's stewardship, the court developed its distinctive character, a commitment to minimising formality, to ensuring that both parties felt they'd been dealt with fairly, and to drawing upon the expertise of counsellors and social scientists alongside the skills of lawyers and judges. Her vision shaped the institution in ways that endure to this day. Each of Her Honour's successors brought their own contribution to the court's development. It's impossible to be comprehensive, but importantly, Chief Justice Nicholson championed the simplification of court procedures and developed differential case management systems, including specialist protocols for cases involving allegations of child abuse. Chief Justice Bryant oversaw the introduction of the less adversarial trial model, a groundbreaking departure from traditional adversarial practice in children's matters that emphasised judicial management of proceedings and the reduction of parental conflict. Chief Justice Pascoe brought to the court all of his experience as Chief Judge of the Federal Circuit Court and took key decisions as the two jurisdictions moved towards consolidation. Australia is, by the standards of many nations, a place of remarkable civil peace. Violence directed at judicial officers or against the institutions of justice has mercifully been rare in our history. It is for that reason that the events of the 1980s were so profoundly shocking. In that decade, the settled peace of Australian legal life was shattered by a series of attacks on judges of this court, attacks without precedent in this country. Justice David Opus was killed at his home in 1980. Justice Richard Gee and his children survived a bombing in 1984. Mrs. Pearl Watson, wife of Justice Ray Watson, was killed by a bomb at her home in the same year, and the Parramatta Courthouse itself was bombed. That this court continued its work in the face of such violence is a testament to the resolve of those who served on it. Those events remind us that the administration of justice sometimes demands not only learning, dedication and integrity, but personal courage of the very highest order. We must not allow them to be forgotten. Over the past 50 years, Australian family law has been an area of continual and at times transformative legislative reform. As the Attorney-General so fluently articulated, successive parliaments have endeavoured to find and adapt solutions to persistent and emerging problems, the recognition of diverse family structures, the protection of children, the response to family violence, and the fair resolution of financial matters upon separation. The nature of disputes that come before this court has also changed markedly. As Australian households have accumulated greater wealth and as financial arrangements have grown in sophistication, the court has increasingly been called upon to resolve questions that could scarcely have been contemplated in 1975. Disputes involving complex corporate structures, trusts, self-managed superannuation funds, equitable interests of various kinds, and the taxation consequences of proposed orders are all now commonplace. The judge who sits in this court today must bring to the task not only the sensitivity that family disputes demand, but a command of commercial and financial principles that rivals that required in any other jurisdiction. Constant societal and economic change means that reform is a constant need. For the rule of law to command the broad support of the community, the institutions that administer it must be seen to respond adequately, fairly, and efficiently to the community's most acute needs. The work of this court is, by its very nature, among the most acute that any court undertakes. It deals with people at moments of profound personal crisis, the breakdown of their most intimate relationships, the welfare of their children, their safety in the face of violence. If Australians who come to this court in those moments do not experience a system that is accessible, responsive, and just, it is not merely the family law that suffers a loss of confidence, but the administration of justice itself. And so the imperative is clear. The continuing improvement of the family law system is not just a matter of institutional housekeeping. It is essential to the maintenance of public confidence in the rule of law and in the institutions that sustain it. This court must continue to evolve to meet the ever-changing demands of the community it serves, and the practising profession shares in that responsibility. Under your leadership, Chief Justice, the court has continued to innovate with energy and purpose. The Lighthouse project, introduced in 2021, of which the attorney has already spoken, is an initiative of international significance. It provides for the screening of family violence risk at the point of filing, ensuring that cases involving the greatest danger are identified early and managed with appropriate care. High-risk matters are directed to the EVIT list, fittingly named, where a judge-led team provides intensive case management and support. These reforms reflect a court that has not been content to rest upon its institutional history, but has sought actively to respond to the most pressing challenges facing Australian families. A court is, of course, more than its constitutive legislation and its procedures. It's the people who give it life, the judges who sit long hours in difficult matters, the registrars and family consultants who work with parties in distress, the court staff who ensure the system functions day after day, and the lawyers, barristers and solicitors alike, who advocate for their clients and who, at their best, help families find a way forward. On behalf of the Australian Bar Association, I pay tribute to all those who have served in this system over the past 50 years. Your work has touched the lives of millions of Australians at moments of great vulnerability. It has been work that has demanded not only legal skill, but patience, empathy, and a commitment to justice that goes beyond the application of rules to facts. 50 years ago, this court was established in the belief that the law could do better for Australian families. That belief has been vindicated, not perfectly, not without difficulty, but substantially and enduringly. The Family Law Act was one of the great reforming statutes of the 20th century in this country. The court that was established to administer it has proved worthy of the vision that created it. The law at its highest is a human institution fashioned to meet human needs. No court in this country better embodies that truth than this one. As we look to the next 50 years, we do so with confidence that this court, under its present leadership and with the continued dedication of all who serve within it, will remain what it has always aspired to be, a place where Australians in their most difficult moments can find justice administered with competence, with humanity, and with respect for the dignity of every person who comes before it. May it please the court.
Thank you very much, Mr. Piselli. Ms. Wolfe.
May it please the court. I echo the acknowledgement of the traditional custodians of the lands on which we meet, the Bunurong and Wurrung Wurundjeri peoples of the Kulin Nation. I pay my deep respects to elders past and present, and I thank Ms. Dowsett SC for the warm welcome to country. Thank you. I acknowledge Your Honour, Chief Justice Alstegren AO, the Attorney General, Michelle Rowland MP, many distinguished judicial officers and guests, colleagues and friends. It is a privilege to appear on behalf of the Law Council of Australia and the Australian legal profession on this significant milestone and to congratulate the court on 50 years of service to the Australian community. Today, we mark more than the anniversary of an institution. We recognise 50 years of a national commitment. That when families fracture, when children's lives are disrupted and upended, when questions of safety and care must be resolved, Australia will respond through a court system that strives to be both authoritative and humane. The Federal Circuit and Family Court of Australia Division 1, formerly the Family Court of Australia, is a specialist court, established at a time of profound social change. Today it is entrusted with the most complex family law trials and an appellate system and a system of work that gives coherence and guidance to the entire system. Its appellate role is not abstract. It's how consistency is built across a continent and how fairness becomes more predictable for the families who rely upon it. 50 years on, it's easy to forget how visionary this court's establishment was. It reflected a recognition that family law required not only legal authority, but a system capable of responding to human complexity with compassion and with dignity. From its earliest conception as a helping court, that ambition was clear, that law could be delivered with humanity and without sacrificing rigour or independence. What has sustained that ambition over 5 decades is the court's willingness to evolve. Family law, as everyone in this room understands, is unlike any other jurisdiction. It deals with people at their most vulnerable and with children who have no choice about the conflict surrounding them. It confronts family violence, coercive control, trauma, and urgent risk. It asks judges to make decisions that will shape a child's daily life, where they live, how they'll be protected, and how they remain connected to the people they love. So when we speak of this court's contribution to justice, we are speaking about something profoundly concrete: the ability of Australians to rebuild their lives with safety, dignity, and the opportunity of a fair hearing. As we reflect on 5 decades of the family court, that commitment to continual development remains evident. The court continues to refine how it resolves conflict fairly, protects the vulnerable, and upholds the rule of law with humanity. Initiatives, as we've heard, such as the Lighthouse Program and specialist lists, including Magellan and Evid, are practical expressions of that very commitment. They are designed to identify risk early, to support vulnerable parties, and above all, to keep children safe. The growing use of these pathways and the feedback from those who rely upon them confirms that they are making a real difference. Former Chief Justice Alistair Nicholson observed that family law sits at the point where the justice system is most visible to ordinary citizens and where their confidence in the law is most directly tested. That observation remains as true today as when it was made. Public confidence in family law is shaped not only by judicial decisions, but by the experience of those who come before the court, whether they feel heard, whether the process is fair, and whether issues of safety and responsibility are treated with seriousness. Family law is where the rule of law is encountered not as an abstract concept, but as a lived experience. Legal practitioners play a vital and critical role in that experience. They assist the court to identify real issues, test evidence, and protect vulnerable parties and support outcomes that are lawful, just, and workable in practice. On behalf of the Law Council of Australia, I acknowledge the contribution of the legal profession, barristers and solicitors alike, whose daily work underpins the proper administration of family law, and through it, public confidence in our legal institutions. Much of what they do is rarely visible. They carry the weight of profound professional responsibility, while also absorbing the trauma, the distress, and the fear experienced by those families they serve. Their work depends not only on intellectual rigour, but on deep emotional intelligence. As they navigate conflict, vulnerability and grief with care and with restraint. In recent years, the profession has also adapted to significant upheaval, substantial legislative change, evolving court expectations, new processes, technology, and changing community needs. Through it all, legal practitioners have shown resilience, professionalism, and unwavering commitment to the rule of law. I also wish to recognise the significant contribution of the Law Council's Family Law section, the largest professional association of family law practitioners in Australia, whose members give generously of their time and expertise to help shape a more workable and responsive family law system. In recent years, they have gone above and beyond, responding to the breadth of reforms and working constructively with the court to support implementation and to improve practice. Their efforts reflect a deep commitment, not only to the profession, but to the families and children whose lives are shaped by this jurisdiction. This shared commitment between the court, the profession, and those who support its work strengthens the administration of law and family law in particular, and the confidence that the community places in it. So today, on behalf of the Australian legal profession, I offer sincere thanks to the judges of Division 1 for the weight you carry and the care with which you make decisions that shape lives. To the registrars and staff whose expertise and professionalism are fundamental to access to justice and whose work is also too often unseen. And to all those who have served this court over the past 50 years, those who have built it, those who have modernised it, and those who continue to shape it for the families who rely upon it. 50 years on, the task is not finished. The pressures on family law remain profound, and the human needs that arrive at this court's door are as complex as ever. But over 5 decades, this court has shown that it can hold together what must be held together: rigour and compassion, authority and accessibility, principle and practicality. On that foundation, I am confident that it will continue to serve all Australians and continue to earn their trust for the next 50 years. May it please the court.
Thank you, Ms Wolfe. Mr Walker.
May it please the court. I also acknowledge the traditional owners of the land on which we meet, the Bunurong and Wurundjeri Woiwurrung peoples. I acknowledge, Your Honour, the Chief Justice, the Attorney General, all judicial officers, my fellow speakers, dignitaries, colleagues and friends. It is my privilege today to speak as Chair of the Family Section of the Law Council of Australia and to represent something like 4,000 members across the country. The Family Law Section has been a strong supporter of this court over many decades, and many of our former members and former executive members have served or continue to serve on this bench. For almost 30 years, family law has been my career and livelihood. For hundreds of thousands of Australians facing exceptionally challenging times, family law and this court have been their lifeline. I know there are some who may believe that the work of this court is focused on endings. In my experience, the reality is that this court is about beginnings, about fresh starts and hopes for a better future. Humanity truly lies at the heart of family law. Few areas of law are as human as family law. Family law dissects the most intimate of human relationships in all their diversity and fragility. In that diversity defines the work of this court. Just as no two families are identical, so too each matter before this court is different. There is no straightforward, cookie-cutter decision to be made. There are no easy, quick determinations. Instead, we rely on and have faith in the compassion, insight, and dedication of the judges, registrars, and officers of this court. In the face of great emotion, often with accompanying conflict, all who work here are tireless in their determination to find the best and fairest outcome for all. And they do so in the face of a workload and exposure to experiences of heartbreak and trauma that would understandably overwhelm anyone. The Federal Circuit and Family Court of Australia Act requires that by reason of knowledge, skills, experience, aptitude, all judges exercising family law jurisdiction must be suitable to deal with family law matters, including matters involving family violence. As we have heard, the court continues to deal with the most complex of family law matters, including matters involving complexity associated with family violence and other risks, allegations of child abuse or serious physical harm, and cases involving international child abduction. While these are the black and white descriptions of the attributes of a judge of this court and its work, they still clearly depict a difficult and highly expert task. The reality is so much more. The diversity of families and the changing nature of their makeup, societal norms and expectations over the past 50 years has required constant adaptation and evolution by this court. Adaptation and evolution that this court has not only embraced, but guided and led, making a significant positive contribution to the diversity and the delivery of justice in this nation. The guiding light throughout has always been to protect children and do what is best for them. In his second reading speech, when the bill, which became the Family Law Act of 1975, was being considered by the Commonwealth Parliament, then Attorney General, the Honourable Lionel Murphy QC, highlighted that the court is required to regard the interests of children as the paramount consideration. And over the past 50 years, the court has proactively and innovatively found ways to support children. When explaining how the bill would support family, Lionel Murphy said there should be provisions to enable marriage that is irretrievably broken down to be dissolved and proper provision made for any children of that family, for fair adjustments of property interests, and for equitable maintenance on the basis of need, all in proceedings that are intended to avoid exacerbating relations between the parties. Families and relationships are complex. Family law is therefore complicated. It requires reaching solutions that can honestly never be perfect, can never provide everything and exactly what everyone involved wishes for. But these solutions must be well considered, balancing competing needs and minimise harm. 50 years on, the how, where and who of the court's work may have changed, but it continues to be a champion for Australian families and do everything within its power to continually reach and exceed this worthy goal. As a former president of the Law Council of Australia once said, no one does family law half-heartedly. It definitely takes heart, and for 50 years, the court has wholeheartedly tackled and delivered on its promise to the community. For 5 decades, the people of Australia have been well served by the court and all who work here. When the Honourable Margaret Peg Lusink was appointed to this court in 1976, she was the first woman to be appointed to a court in the state of Victoria. It would be another 7 years before the first female Victorian judicial officer was appointed to the Children's Court. In 1985, amongst other appointments, the late Sally Brown was appointed as a magistrate of the Magistrates Court and would later serve as Chief Magistrate before being appointed to this court. For a number of years, female law graduates have outnumbered male graduates. And for a number of years, this court has reflected the diversity of our society. As Ruth Bader Ginsburg remarked, women belong in all places where decisions are being made. It shouldn't be that women are the exception. Hopefully more law students will discover the values of the work that we do in this court and make their choice for a career in this rewarding jurisdiction. Reflecting on the court's legacy inspires great pride and gratitude. But perhaps more importantly, it forces us to think about how we want this court and family law in Australia to support our community over the next 50 years. We cannot know what changes may be over the horizon, which will require the court to pivot and adjust. But what the past 50 years has shown us is that the court's response will be characterised by its passion and energy for continual self-improvement and its understanding and respect for humanity, which must underpin family law if it is to successfully help people during the most difficult times in their lives. May it please the court.
Thanks very much, Mr. Walker. I want to thank each of the speakers for your kind remarks and the respect you have given to the court, and particularly the Attorney General for her time being here today. It's a great honour for the court. Today we reflect upon how far we've come in the last half of the century. This is an important milestone and opportunity for us to reflect on the importance of having a specialist superior family court dedicated to Australian families. This is one of innovation and resilience while remembering the importance of access to justice. Following much debate and public debate over many years, this court was created by the Family Law Act 1975. At the time, as we've heard, a groundbreaking piece of legislation which reflected changing social norms in Australia. The path to creating a standalone family court was not easy or straightforward. There were in fact multiple frameworks proposed, including a federal court with a family law division. This proposal was only narrowly defeated by only 2 votes in 1974 and again in a tied vote in 1975. It was ultimately decided a standalone Superior Court of Record, which would go on to be the Senior Court, with specialist judges and in-house counsellors would be the best to serve Australian communities, with a more informal atmosphere to encourage resolution rather than litigation. All states and territories, save for Western Australia, agreed to this new court, and with the latter being subject to the court's appellant jurisdiction. Prior to 1975, divorce was fault-based, and there was little limits on what could be reported or made public. Divorce proceedings were a matter for state courts, which did not have fit-for-purpose facilities we enjoy today. The Act introduced only one ground of divorce, a ground which did not require any finding of fault and only required that the relationship had broke down irretrievably and the parties had been separated for 12 months. On that basis, on the 5th of January 1976, the Honourable Elizabeth Evatt, AC, who's here with us today, was sworn in as the first Chief Judge of the Family Court of Australia. Chief Judge Evatt was sworn in by the Honourable Lionel Murphy QC, who was then Justice of the High Court of Australia and had been Attorney General when the Act had passed, and was a driving force behind the legislative change. Evatt was quickly joined by 4 other colleagues on that day. Their Honours John Ellis AM, Austin Ash ACKC, Ken Pawley and John Marshall. Austin Ash, of course, would go on to be Chief Justice of Northern Territory and indeed its administrator. There were registries established then in Melbourne, Sydney, Canberra, Adelaide, Brisbane and Hobart. As the history of this court between the time of the Act had passed and in coming into force, our 5 judges faced an almost impossible dilemma. As many of you may remember, supply was blocked, the government was dismissed and went on to lose the next election. The then Attorney General, who was no fan of the Commonwealth Family Court, was fortuitously moved to a different portfolio. His replacement, the Honourable Robert Ellicott, ACKC, luckily saw the new court being established. These first registries were not located in traditional court buildings, but rather in a variety of Commonwealth office space, which was to keep the ethos of the court being more informal. This quickly proved to be a great challenge, with many of the offices being far too small, particularly as the court was so popular, particularly on day one. On this first day of the court's operations, queues literally formed around the country, with practitioners and parties waiting to lodge divorce applications under the new system, indeed with no fault. And parties wanting to lodge the divorce applications in that time were vast. Indeed, they also required more privacy. By its 10th anniversary, the court had processed almost 500,000 divorces. Funding was a continuing issue for the first 15 years of the court's operation, and it is through the sheer hard work and determination of the judges and the court staff, the court was able to succeed at that time. Again, I want to pay tribute to Elizabeth Evatt's leadership, which was simply outstanding during that time. Not only was she starting a new court, but faced significant challenges, and it's been noted that her calmness, skill and steely determination was the reason why the court survived and was established and succeeded. Alistair Nicholson followed from Chief Justice Evatt as head of the jurisdiction, being sworn in on the 1st of February 1988, and continued Chief Justice Evatt's legacy of innovation of the court. This included pioneering the court's work for First Nations families, refining case management processes and creating a Magellan list for high-risk matters. I acknowledge and thank His Honour for his service. I know he's watching online today, and also thank him for the service to the people of Australia. On the 5th of July 2004, the then Chief Judge of the Federal Magistrates Court, the Honourable Diana Bryant AOKC, was sworn in as Chief Justice of this court, and is now, and she was previously Chief Judge of the Federal Magistrates Court that went on to be the Federal Circuit Court, and now the Federal Circuit and Family Court Division 2. The Honourable John Pascoe, ACCVO, was appointed as Chief Justice 13 years later, after also serving as Chief Judge of the Federal Circuit Court. Both those individuals, both those leaders, brought impressive leadership and their skills to help guide the court through difficult and challenging times. Diana, in particular, enhanced the court's reputation, particularly worldwide. I join Mr. Casello's mention of the Parramatta Registry and perhaps a dark time in the court's history, which should always be remembered. The court remembers and acknowledges the service of the Honourable David Opas, who was murdered on the 23 June 1980 at his home. Then the early 1980s saw multiple bombings, including the murder of Miss Pearl Watson, the wife of the Honourable Ray Watson, and the bombing of the home of the Honourable Richard Gee. We acknowledge the bravery and sacrifice of those who sat on the bench or provided support at home, and the families of loved ones for those who worked on that day. These qualities were personified, I think, by the Honourable Gary Watts AM, who we also have tonight, and I want to acknowledge him for his extraordinary career, from being a solicitor to a judge in this court and becoming a giant in the family law. Through adversity and having to testify at the murder of the trial of colleagues and the trial of his own attempted murder, to continuing to serve the Australian public, Gary Watts stands as an idea of what a judge or judicial officer should be. I also cannot thank each of the judges by name, but I extend my gratitude to every one of them. Judicial office is not suited for all. It carries extraordinary weight of responsibility. My colleagues on the bench, past and present, have answered the call to public life and public service, public scrutiny, and indeed public office, along with the families who sit beside them. I thank you all sincerely for your commitment to an institution that is so fundamental to our society. The family court has not existed without controversy, but at times it's been reflective of the importance of its function to the Australian people. This court has been the envy of other Commonwealth and civil law countries who have not had such a comprehensive resources to resolve family law disputes. Having dedicated judges, registrars, mentors and court child experts, it has created a versatile court which is able to prioritise the safety of children and ensure just and equitable outcomes. As started by the legacy of our former Chief Justices, this court has since continued to create specialist lists as required to ensure that matters are being triaged and dealt with as quickly as possible. Most recently, this has included the critical incident list, which provides fast-track outcomes for families struck by tragedy, and the Evatt list, named, of course, after our first Chief Justice, for high-risk matters. I'm also delighted to indicate today that another list will be created in the name of Alistair Nicholson in relation to Indigenous hearings in country. The Evatt list has made a notable impact to our court, recognising the impacts of family violence and the extra support and handling needed for those matters where parties and children remain at high risk. By using social science and evidence-based models, along with the benefits of information sharing between state and Commonwealth agencies, the court is able to be informed about decisions in a timely manner, which is critical to access to justice. While from the outside the work of the court may be seen as niche, it has grown into an area of law requiring an understanding of commercial and corporate law, bankruptcy, family law, violence orders, child protection, equity, trust, and the intersection of state legislative regimes. This has meant that, though this court is specialised, its success relies upon a broad-based knowledge of all other areas of law, many of which the court's judicial officers have brought with them. Given these complexities and the high personal nature of family law, the jurisdiction has long been the subject of public and political conversation and has undergone, would you believe, an extraordinary 75 separate reviews and parliamentary inquiries in 50 years. more than any other area of the law. The court has continued to demonstrate its importance, its value, and its willingness to be introspective and make changes where necessary. Perhaps one of the most dynamic changes was in 2021 when the Federal Circuit and Family Court of Australia Act was passed and allowed the court to introduce common case management framework, rules, forms and procedures for family law jurisdiction with the former Federal Circuit Court, now Division 2. These changes have meant that only the most complicated cases, including Hague matters, international relocation and complex financial proceedings, are heard by this court, as well as appeals, giving them the ability to be heard as soon as possible. Thanks to the support of the government, this has led to significant changes in clearance rates and a reduction in time to trial. And in relation to appeals, the time is almost halved. This court has had the great fortune of having so many judges elevated from Division 2, bringing their dedication and hard work. It is a unique belief of this court that we're able to appoint experienced judges who have deep understanding of the unique challenges that this jurisdiction brings. This court has grown with the opportunity and reform agenda that has followed and has been significant. This court has remained a specialist skill set in ensuring safety of litigants and children in the most difficult circumstances and continues to dedicate itself to ensuring access to justice. Recent innovations of the court have included to strive to deliver access to justice, including specialist Indigenous lists alongside skill of Indigenous family liaison officers, a national court dog program which assists litigants to feel safe, calm and supported when giving evidence, and also when children have to interact with the court child experts. This is a court that demonstrated that we cannot rest on our laurels or our previous achievements. We must continue to see what we can do to improve the system of justice for Australian families. Practitioners who work in this court have to balance this by assisting clients through the difficult and challenging times, and is a testament to the legal profession who work day in, day out in our courts. They're able to assist the Australian public so well. This jurisdiction is also unique in that it had practitioners who have spent the past 50 years of their career working under the Family Law Act and have grown alongside the court. The skills and experience of these practitioners, many of them are sitting at the bar table, have imparted to the next generation of practitioners skill which is invaluable. This court plays an important role in responding to the current national crisis and domestic violence. Far too many cases that come before this court involve more than one risk factor in relation to family and domestic violence. This court is committed to work in line with the 10-year national plan by the government to eradicate family and domestic violence. It sees the impacts on families far too readily after it occurs. It is time for Australian families and indeed Australian men, I think, to take note and show some leadership. It's time for an efficient and effective first step, a national campaign which encourages men to be part of the conversation, leading boys and young men, that this behaviour is just not on. Women have led the charge. It's now time male leaders have the courage and the integrity to step up and lead the way. As a court, we've endeavoured to play a part in that conversation through the help of sport. Let us hope that a nationally coordinated program can be advanced in the court's 50th anniversary year and give Australian families a safe and positive future. The court's understanding of family violence has changed over the past 50 years, and the court is more alert than ever to the role it plays in ensuring that family violence is recognised and the outcomes of matters ensure that children and litigants are kept safe. An unwavering focus is the best interest of the child, and that is something the court will always uphold. I acknowledge the court's past Deputy Chief Justices, the Honourable Alan Bartlett, AO, and also the Honourable John Folkes, who's here today. The role of the Deputy Chief Justice is indispensable, providing diversity in leadership and sound guidance to not only the head of jurisdiction, but all the judges of the court. I also acknowledge our case management judges, as well as all the judges who sit on the external committees and councils. I would like to also at this stage comment and pay tribute to the former heads of jurisdiction in relation to appeals, Justices Strickland, Thackeray, Finn and May, and including Justice Chanel, who's recently taken over as administrative head of the appeal jurisdiction, taking over from Justice Austin, who has been in that role for a number of years and has been meticulous in the way he's led the appellant jurisdiction with such great success. I acknowledge also the court's past and present principal registrars and chief executive officers who do such an incredible job. In particular, I want to welcome and thank and acknowledge the dedication of our current CEO and principal registrar, David Pringle, PSM, and thank him for his support as he continues to provide me and the court with great strength, and that of his deputy, Virginia Wilson. We also acknowledge our policy and legal team for the work they've done, including Jordan DiCarlo and Fraser Jones. I also acknowledge all the staff, registrars, court child experts, Indigenous family liaison officers, associates, legal case managers, administrative and corporate and registry staff, the extraordinary work they do and the tireless work they do day in, day out. I also just want to very carefully mention, although he won't want me to do so, that this is Terry Maguire's last sitting. He will retire on Saturday. We are sincerely thankful to him for his service to our court and we'll miss him greatly. In preparation for the court's 50th anniversary, interviews were conducted with former Chief Justices and judges. I now invite you to turn your attention to the screen.
Ways given the federal parliament jurisdiction in, and I'll quote, marriage, and secondly, divorce and matrimonial causes, and in relation thereto, parental rights and the custody and guardianship of infants.
The family court opened in January 1976, and hundreds of people, if not thousands of people, came to the court.
I can remember the queue that went right downstairs, down the fire escape.
In the old days, to get divorce, you had to paint the other side black. Then you got a divorce on the ground of desertion or adultery or cruelty or drunkenness.
A lot of people had been waiting patiently for the act to come into force so they could get their divorce.
Elizabeth Evatt started this court with very little in terms of resources.
They set to in those latter months of 1975 in trying to start a court from nothing.
We were a whole lot of like apprentice judges.
The Family Law Act over the last 50 years has swung like a pendulum one way or the other, depending upon the ascendancy of the interest groups that are vocal in the community.
There were certain elements in the community that were hostile to the family court.
There were a lot of protests, the black shirts, the men who were wearing black shirts and intimidating women.
And then David Oppas was shot.
Leonard Warwick was ultimately convicted of 3 murders, blowing up the court building.
A family court is something more than a court. And I think that on any view, it's the fact that this court has had a broader focus that stands out as one of its great successes.
The new court includes within its structure a counselling and welfare service.
It is, I think, in that respect, the envy of the world.
When I was Attorney General, there was little coordination and harmony between the courts, and the former government proposed effectively consolidating the courts administratively.
That represented really a significant, almost seismic change in the way the court had conducted itself. Things suddenly sped up, so it's been revolutionary.
I think it's absolutely vital that people have confidence in the court system. We have to make sure that we give fair and reasonable hearings, that we make sure that people actually are treated with respect. Risk identification has got so much better than it was. We now have to, as a matter of course, examine and have notices of risk in every case when it starts, not down the track. That makes a massive difference to their experience of the court, and we're able to diminish the possibility of them being further traumatised as a result of being in the court system. It's always been very controversial, these courts, because of the very nature of the work we do, the emotive nature of it. And I think the originators of this, I think they'd be really proud of the legacy they've created, but also each and every judge who's in the court at the moment and has been in the court should be really proud of what they've done. On the 25th anniversary of this court, Justice Nicholson, or Chief Justice Nicholson as he was, reflected on what he saw as the future of this court in the coming years. I believe that we will continue to be at the forefront of innovation in the area of family law and in the wider areas of courts generally with respect to case management, court governance and information technology, because we build and learn from the past and from the court, and this court is well placed to meet the challenges that lie ahead. I'm happy to say that I think that Chief Justice Nicholson's words ring true. Just as families have changed over some time, so has this court. The mirror that we hold up to the Australian community means we must be quicker to adapt and change. It is my hope that in another 50 years, the court will continue to be at the forefront of innovation and continue to play an important role in the social fabric of this nation. We have achieved so much in the last 50 years, but I have no doubt the next 50 will be even more challenging and require more achievements and more energy. Thank you all for honouring us today with your attendance. Please join us for refreshments upstairs. Adjourn the court.
Silence, all stand and remain standing. The Federal Circuit and Family Court of Australia, Division 1 is now adjourned.